The file was still on his desk, where he had left it the night before. And the case clerk, who came in at 7:15 and saw him slumped in the swivel chair with the office lights on, said later that she did not know whether to be relieved or afraid. He had not been drinking. That part was important, and she remembered it specifically. There was a paper cup of black coffee on the blotter, half full, gone cold, and the bottle that had lived in his bottom drawer for 6 years was not in the bottom drawer anymore. It was on top of the file cabinet in the corner, where he had set it Sunday morning at 5:11 a.m. As a kind of bet with himself. He had not touched it since. The cap had a thin film of dust on it. That was how the courtroom witness, a paralegal named Renata Quist, would tell the story afterward, beginning not with the verdict, but with the unopened bottle and the man who had not touched it for 6 days. His name on the door read T. M. Orley, Assistant Public Advocate, and below that, in smaller letters that someone had added in marker and not had the heart to scrape off, Courtroom 6 Rotation. He was 48. He had been a public defender for 19 years. He had been on the brink of being struck from the rolls for 14 of the last 20 months, and on Sunday night the state bar had finalized the date. The disbarment hearing was set for 2 weeks out, Friday the 22nd, 10 a.m. He had read the certified letter twice. Then he had sat at his desk and looked at the bottle. Then he had walked it across the room and put it on top of the cabinet and washed the glass under the tap and turned the tap off and gone home and slept for the first time in 11 nights. This was the morning after. 6 days sober, 14 days to disbarment. And on the blotter, in front of him, was a thin manila folder, marked People v. 5. Kesh. Assigned this week docket 41. The case nobody else in the office had wanted. The case the supervisor had set on his desk, with the words, "Clean this one up." They want it gone by Friday. Renata, watching from the doorway with a stack of motions to be signed, would remember she almost did not interrupt him. He was not slumped now. He was reading. The case file was open to the booking sheet. He had taken a fresh legal pad from the supply cabinet, and 3 pages of it were already filled with his small, square handwriting. A list of names, a list of dates, a list of questions, each numbered, each in its own line. The defendant was a woman of 53 named Maricela Kesh, employed for 9 years as a night shift cleaner at Velum Hospital, charged with the felony theft of $47,000 in pharmaceutical inventory from a third-floor supply cabinet that had been broken into between the hours of 2 and 4 a.m. on a Thursday in February. The hospital security officer had cited her keycard as the last credentialed entry on the cabinet log. The police had come on a Tuesday afternoon, knocked on her door at the apartment she shared with her elderly mother, told her she didn't belong on the floor she'd cleaned for 9 years, and walked her out in her coat. The arraignment had been 6 weeks earlier. The plea offer was on the file's left flap, paper-clipped. 2 years, suspended, 10 years probation, full restitution. The note from the prior attorney was on the right, recommend acceptance, no defense. Orley read the prior attorney's note a second time. He underlined the words, no defense, with a single black line. Then he wrote, beneath them, in the same square hand, then, we will build one. He picked up the phone and called the hospital pharmacy. He asked for the dispensing technician on duty the morning of February 12th. The hospital had told the police it was a man named Davies. When Orley called Davies's pager and Davies called back from a gas station in the next county, Davies said he had transferred in September and had not been on the floor in 5 months. Orley wrote the date of Davies's transfer on the legal pad and circled it. He called Maricela Kesh next. She answered on the second ring. He told her his name. He told her he had been assigned. He told her he had read the prior attorney's note and disagreed with it, and that if she would meet him at his office at 3 that afternoon, he would explain why. She was quiet for a moment. Then she said, in a voice that did not break, I did not take anything, Mr. Orley. I would like the chance to say that out loud with someone listening. He said, 3 o'clock, bring whatever you have. At 3, she was at the door. She wore a long gray coat and a navy blouse buttoned to the collar. Her hands were folded in her lap. She had brought a brown paper bag. Inside the bag, in a stack tied with kitchen twine, were 47 pharmacy logs, handwritten copies of the third-floor supply cabinet's nightly inventory check kept by her in a spiral notebook on her cleaning cart for the last 3 years, dated and signed, because, she said, once a needle had been missed from a tray and the responsibility had nearly fallen on her, and after that she had decided she would write down everything she had ever seen, open or closed, on the floors she cleaned. 47 nights' worth. Each one signed M.K. Each one timed. Each one stamped, in the upper right corner, with a small red number, the pharmacy's own dispensing sequence number, because she had asked the second-shift pharmacist to initial them as he closed up, and the second-shift pharmacist had said, kindly, that as long as it was her own log he didn't mind. Orlais set the bag on the desk. He looked at it for a long time. He looked at Maricela Kesh. Then he picked up his pen. For 6 days he did not leave the office before 11. He kept the bottle on top of the file cabinet where he could see it from the desk, and he kept the certified disbarment letter folded in his inside pocket so the weight of it sat against his ribs while he worked. The clock on the wall ticked. The hospital had given the prosecutor a clean story and a tidy folder, and any attorney willing to read for 10 minutes would have accepted the plea by lunch. Orlais did not have lunch. He cross-referenced her 47 logs against the hospital's internal pharmacy dispensing record, which the prosecutor had filed in discovery as Exhibit 9. 22 of the logs matched the hospital's record exactly. 25 did not. The 25 that did not match all carried small red dispensing sequence numbers that had been altered on the hospital's side, a 1 rewritten as a 4, a 3 rewritten as an 8, the strokes thicker, the ink different. He laid the logs out on his conference table in 2 parallel rows. He photographed each one. He took the photographs to a typesetting friend who had retired from the state crime lab 11 years ago, and the retired typesetter, looking through a loop with the patience of a watchmaker, said the alterations were not made by Maricela Kesh and were not made by the pharmacist either. They had been made later, on a higher-end laser printer, in a different ink. He drew the obvious line on his legal pad. Whoever had altered the hospital's dispensing record had needed to do it because the real record disagreed with the false story. He underlined the word real twice. On the 4th day, he subpoenaed the hospital's procurement contracts. On the 5th day, at 6 in the morning, he had what he needed. Velum Hospital had filed an insurance claim for the missing inventory the same Thursday. Maricela Kesh's keycard appeared on the cabinet log $53,000 to the hospital's carrier, payable on confirmed theft, payable on a closed police report, payable on a conviction. The man who had signed the insurance claim was the hospital's chief operating officer, a man named Edgar Pell. The man who had altered the pharmacy log was the same Edgar Pell, not in his own hand, but on his terminal, with his credential, between 2 a.m. and 3 a.m. On the morning after Maricela Kesh had clocked out and gone home, Orlais called the prosecutor's office. He asked for a status hearing. He told the deputy district attorney, a young woman named Philema Joss, that he had material exculpatory evidence and intended to move to dismiss. Joss laughed at first. Then, when he laid out 3 sentences of what he had, she stopped laughing. She said she would calendar it. The hearing was set for the following Wednesday at 10. By 4 o'clock the same day, she said. That was the cutoff. The judge wanted everything in or out by 4. Renata Quist, who would tell the story afterward to a small audience at her sister's kitchen table, said later that the corridor outside courtroom 6B that Wednesday morning was the quietest she had ever heard it. The hospital had sent its in-house counsel and 2 senior partners from an outside firm. Edgar Pell was there in a charcoal suit, leaning against the wall with his arms folded, smiling at a junior associate's joke. Maricela Kesh sat on the bench between her elderly mother and a neighbor. Hands folded, navy blouse, gray coat, composed. Orlais walked in with 1 accordion file under his arm. He did not look at Pell. The judge was a woman named Sandra Yellon, gray hair pinned, sleeves of her robe a little too long. She had read his pleading. She had read the prosecutor's response. She looked at Orlais over her half-glasses and said, "Counsel, you have asked for a great deal. Make me believe it." He did not raise his voice. He laid the 47 pharmacy logs on the bar table in 2 parallel rows. 22 matched and 25 contested, and walked Judge Yellen and the prosecutor and the gallery through them one by one. He set up the retired typesetter's enlarged photographs on the easel and showed where the strokes had thickened. He read into the record the procurement contract clause that turned a confirmed theft into a payable insurance claim. He produced the audit trail from the pharmacy terminal obtained on subpoena, served 51 hours earlier, that showed Edgar Pell's credential entering the dispensing record at 2:14 and exiting at 3:03 on the morning after Maricela Kesh had clocked out at 1:55. Pell's smile faded somewhere around the second photograph. The prosecutor stood. She did not, to her credit, try to defend the indictment. Philima Joss said only, "The people withdraw the charges and join in the motion to dismiss with prejudice. We will be opening a new file on the underlying facts." She glanced sideways at Edgar Pell when she said it. Judge Yellen tapped her pen twice on the bench and said, "The motion is granted. The charges against Miss Kesh are dismissed with prejudice." The court will refer the altered records and the insurance filing to the State Attorney General's Economic Crimes Unit for review and to the State Department of Insurance for parallel review. Miss Kesh, you are free to go. The court regrets the months you carried this. It was 3 minutes past 4. The gallery did not applaud. A nurse from the hospital who had come on her own time and sat in the back row covered her mouth with one hand and lowered it again. A bailiff at the side door, who had watched these courtrooms for 21 years, gave a single small nod that nobody outside the room would have read as anything at all. Renata Quist felt the silence settle, the particular silence that only happens when a record corrects itself in real time, and she would later say that what she remembered most was the sound of Maricela Kesh's mother letting out a slow breath she had clearly been holding since the gavel began. Edgar Pell did not look at Maricela Kesh. He looked at his outside counsel and waited to be told what to do. The bailiff did not arrest him. That would come later, lawfully, when the Attorney General was ready. The hospital's in-house counsel asked for 10 minutes in the small conference room and was given 5. By the time he came out, Pell had been placed on administrative suspension pending internal review. The insurance claim had been withdrawn from the carrier on the record, and Velum Hospital's chief executive had been requested to appear before the hospital board the following morning. None of it was vengeance. All of it was procedure. Maricela Kesh stood. She did not weep. She turned to Orlais and said, "Thank you for listening." Her elderly mother held her hand. They walked out together. In the hallway, Orlais sat down on the bench. His hands were shaking a little, the way hands shake after a long task that has been carried correctly. Renata Quist watched him. She watched him take a long breath. She watched him take out the certified letter from the state bar that he had been carrying folded in his inside coat pocket since Sunday, the disbarment notice for the following Friday. She watched him read it once. She watched him fold it again. She watched him put it back. He stood up. He walked back to the office. The bottle was still on top of the file cabinet. He looked at it. He did not pick it up. He sat down at the desk and wrote 3 things on his legal pad in his small, square hand. The first was a letter to the state bar, requesting that his disbarment hearing be deferred 60 days so that he might present as part of his record the work of the preceding month. He attached, by reference, a copy of the dismissal order and the court's referral. He did not ask for forgiveness. He asked only that the record be considered. The second was a referral to the county's wrongful conviction restitution panel, requesting that Maricela Kesh be compensated for her 6 weeks under arrest, lawful and modest, paid out of a fund existing for that purpose. The third was a single line, addressed to no one, and signed at the bottom only with his own initials. It read, Day 7. Day 7. The hearing on the deferment was granted 10 days later. He stood before the bar's review committee in the same suit he had worn in front of Judge Yellen, and he did not ask them to overlook the 19 years. He laid them out, one by one, the missed filings, the missed hearings, the apologies he had owed and not delivered. He said he had been wrong, in plain language, without ornament. He said he could not undo it. He said he had been sober 16 days at that point. He said he would do the work in front of him, one day at a time, and that the record would, in time, either justify him or not. The committee deferred the disbarment 1 year, conditioned on weekly reporting and a mentor at the bar's lawyer assistance program. They wrote in their order that they had considered, in particular, the work of the previous month. They did not call it redemption, they called it evidence. Renata Quist, telling the story afterward, said the most surprising part was none of the obvious parts, not the altered pharmacy logs, not the insurance claim, not the hospital chief operating officer's smile fading. The most surprising part, she said, was the moment outside courtroom 6B, when Maricela Kesh, walking past Edgar Pell on her way out with her mother on her arm, did not look at him at all. Pell tried to speak. He started to say her name. Maricela Kesh kept walking. The composure of it, Renata said, was the closest thing to dignity restored she had ever seen in 9 years working in that courthouse. It was, she added, the kind of composure a person earns by being given a fair count of their own days. Theo Orlais stood at the elevator and watched the Kesh mother and daughter step out into the autumn light of Fountain Street. He did not follow them. He had not earned that. He had only earned the right to do the next correct thing, and the next, and the next, and the right to keep the bottle on the top of the file cabinet, where he could see it every morning, and choose, again, not to take it down. On the morning of the deferred hearing's first quarterly check-in, he arrived at the Bar Association's offices at 7:51 a.m., 9 minutes early. The file under his arm. He had been sober 101 days. He laid the file on the desk. He sat down. He kept his hands still on his knees. He waited for the door to open. Hallway. The law had done the rest the way the law was supposed to. And the man with the bottle on top of his file cabinet, who had not touched it in 6 days and would not touch it on the 7th, walked back to his office that afternoon and did the next thing on his list. He never did name the morning after as a beginning. He simply called it day 7, and then day 8, and then day 9. The work in front of him was enough. The dignity she had carried into court, she had carried out of it intact, and the law, for once, had moved at her speed and not at the speed of the men who had counted on it not noticing. That was the cold reckoning of it. Not cruelty, not revenge, only the patient sum of what was on the record, and the patient sum of what had to be added to it. The witness who watched changed her mind not about the verdict, but about the man who had asked for it, and the woman who had asked for nothing but to be heard, and the law that, every now and then, when somebody refused to stop reading the file, remembered what it was for.